Well, hello everyone. I think there's just four of us here. I would love it if you guys would put your screens on so I can see you because otherwise I feel like I'm talking to myself. So whoever's out there, if you would just put your video on if you don't mind, that helps me out. Otherwise, I feel like I'm all alone here. And you could even put your microphone on. You don't have to mute yourself. Hi, thanks, Sean. I appreciate it. Otherwise, I feel like I'm talking to myself, and that's weird. So, yeah, anybody who's listening, put your videos on so I can see you. Um, and yeah, and if you have questions, please well, I'm not really good at checking the chat thing, so just kind of wave at me or start talking. But we are here to talk about arbitration. So hopefully everybody knows what you're on the right Zoom call. And they asked me just to go over arbitration so that everybody can kind of understand what that looks like for your clients and how it's changed over the last couple of years. So that's what I'm going to do. Oh, and by the way, I'm Michelle Smith. If I haven't met some of you, I'm the attorney that reviews all of your documents. And, if you have questions, you can always give me a call or email me about anything. So let's get started. What is arbitration? That was kind of the first thing that they wanted me to talk about, just kind of lay out what arbitration is. So arbitration is a dispute resolution process that it's used as an alternative to the court system. So if there's a dispute between opposing parties, instead of going to court, they could have elected to go an alternative route, in this case, arbitration. And an arbitrator would be assigned to the case. And usually that arbitration takes place at the house where the dispute is over. And a decision is made and it's binding and there's no appeal. So that's kind of the gist of what arbitration is. And now I'm going to break it down a little bit. And again, please let me know if you have questions. So August 1st, 1998, when they revised, or not 98, I don't think it was 98. It was a few years ago. On August 1st, they revised the arbitration rules. 2018, I think is what I meant to say. And they changed the rules of arbitration. It used to be either you agreed to do arbitration or you went to court if there was issues after the transaction occurred. Now, if all the parties sign arbitration, what you are actually agreeing to is going to arbitration if the claim is over $15,000. So any claim under $15,000 goes to conciliation court. Anything over $15,000, if all parties have agreed, would go to arbitration. So that's a huge difference in what used to be arbitration. And $15,000 is currently the legal limit for conciliation court. Anything over $15,000 is when you would have to go to district court. So that is what the limit is set at right now. But if you actually read through the arbitration agreement everybody signs, that can vary. If the courts raise the conciliation court limit, so will the arbitration be raised. So if it goes up to $18,000, then everybody would arbitrate after $18,000, et cetera. So right now it's at $15,000. And so when everybody signs that document, they're agreeing that instead of going into a court of law, they would rather go through an arbitration. When I say all parties, I mean all parties, including realtors. So in order for arbitration to be binding, both the buyers and the sellers, as well as their representatives, have had to have signed the arbitration agreement. If a party did not sign it at the time of the purchase, that the purchase agreement was executed, then it is not binding. And arbitration is not an option unless all parties agree at some point that they want to do some sort of alternative dispute resolution. But the only way it is a binding arbitration agreement is if it is signed by all parties at the time of the purchase agreement has been executed. So any questions on that? Looking at my chat and my Screens? No? Okay, so we'll keep going. So some of the other basics to remember is that people have 24 months after the closing date in order to file an arbitration. So that's one of, I guess, the benefits of arbitration or the negatives of arbitration, depending on how you look at it. But there are only 24 months available to you to avail yourself of the arbitration process. After that point, you cannot bring any claim against the opposing party unless there is some finding of fraud that may overturn that 24 months, but it's very hard to do that. Not fraud like from a disclosure, property disclosure standpoint, but fraud in the process somewhere that would maybe overturn that 24 months, but it's very hard to. So generally, if people sign arbitration, they have 24 months to file that if they find a relative dispute. So those are some of the basics that I wanted to talk about, and then we'll get into a little bit more of the specifics. I also wanted to remind everybody that arbitration is not part of the purchase agreement. So you do still have a valid purchase agreement, whether or not arbitration is included, whether it's signed, whether it's not signed, whether it's half signed, doesn't matter. It doesn't affect the validity of the purchase agreement if you have an issue going on with whether the arbitration agreement was signed or not signed or whatever. So it is not part of the purchase agreement. So what I wanted to do is talk about how to file an arbitration. So if you get a call from a client after the fact who says, I have a problem, we all signed arbitration, I want to arbitrate, what do I do? Well, first and foremost, it's always better to see if the parties can work things out, maybe voluntarily and amicably before you enter into either a court situation or an arbitration. But if that has been exhausted and nothing has been able to be worked out, then arbitration may be their route if all people signed it. So how do they do that? What do they do? Well, right on the arbitration agreement that everybody signed, there is the NCDS, which is the National Center for Dispute Settlement. That's the organization MAR uses. And it has their contact information on there. They would call or email the NCDS and they would ask them for a submission form. And the submission form would be filled out. They would help them if they had questions on the submission form. They would then tell them that they had to submit that form along with, and here's where it gets a little confusing, 4 copies of that demand or submission form, 2 copies of the complete purchase agreement, 2 copies of the arbitration agreement, and 2 copies of any inspection reports. So it's a lot of paperwork. This is not a paperless type of transaction like people are looking for. There's a lot of paperwork. That is what will be turned in along with the filing fee, which we'll go over because it differs depending on the size of the claim. And then the NCDS actually takes care of getting that information to the opposing party. And then a hearing will be set within 90 days. They're bound to make sure that they get it done within 90 days. An arbitrator will be selected. Everybody has a chance to kind of cross off arbitrators they don't want. They're given a list and, arbitrator is selected at that point. And then the arbitration takes place right at the house. I would say 99.9% of the time it takes place right at the house, and within 30 days a decision is made. And it is, as I said at the beginning, binding. There's no appeal to arbitration. So some people like that and some people don't, where if you're in a court of law, you can appeal decisions. Arbitration, it is done. So that is a synopsis of the arbitration process. What I really wanted to talk to everybody about is to remind them that MAR put out these fabulous pamphlets 2 years ago when the rules changed to $15,000 limit to go to arbitration. they put out, it's like a 20-page pamphlet, and it's on Instanet, and it's something that every single client should be given. And when should they be given this pamphlet on what is arbitration and how does it look? They should be given that pamphlet at the time of your first initial meeting with your client, not at the time of purchase agreement. So if you meet with your sellers and you're getting the listing paperwork signed, that is when they should be given the arbitration pamphlet. That way, they have time to look it over and decide at the time the purchase agreement comes, do they want to sign arbitration or don't they? This completely takes it all out of the hands of the agent. We don't have to explain anything, which is what I like, because you're not attorneys and you don't want to tell them, should they sign it? Shouldn't they? What are the benefits? This pamphlet talks about everything. It goes through the pros and the cons of it. It talks about the fees. It talks about what they should do prior to filing an arbitration, what types of things they should think about before going to arbitration, and that they're allowed to have attorneys at arbitration if they choose. So make sure you give that to them ahead of time. And with buyers, hopefully you're meeting with the buyer. Maybe it's online. You can, when you're sending them their buyer contracts, nowadays, I guess more things are done this way. But when they're signing their buyer contracts and their agency disclosure, that's when they should be given their pamphlet about arbitration, because they can look at it and then they won't be rushed at the time of the purchase agreement as to should we sign arbitration or should we not. They will have read through it and they can make their decision, and you can keep referring them back to that pamphlet, because that's where you should be referring them whenever they have questions. The biggest problem agents run into is trying to steer a client one way or the other. And I get the question all the time, should we sign this? What do you think? If it was you, Michelle, what would you do? Honestly, there are situations where I was so glad that we went to arbitration. And there were situations where I really wish we were in a court of law instead. So you don't know which way to go. So we never want to be the ones to tell them. They have to make that decision on their own, as long as they are fully educated on the process. And those packets from NCDS, it's fantastic. I'm telling you, I was so impressed by it. I couldn't believe it. That when they put that out, it was exactly what I had been waiting for. And so I'm really happy. And if you guys haven't taken a look at it, you should. You should just peruse it.
Michelle, do you know where we can find that? Do you think you could screen share and show where that is?
Can you say that again? I didn't have my volume up. Sorry.
Do you think you could screen share and show where that is?
I'm going to try. Let's see if I can do it. All right. Okay, can everybody see this?
Yep.
Yep, okay. So this is what it looks like. Honestly, I think it's 20 pages. Yeah, it's 20 pages long. And it is, from what Ann told me, it's on Instanet. So you should be able to find it when you're finding your purchase agreement, all your documents. Apparently it's on Instanet. I don't know your guys's how to do that, but I can show you what it is. So the first 8 pages of it are like a letter from NCDS, and it talks about everything. The right to object, serving of notice, modification. I mean, literally exactly what the process looks like, and it's perfect. Then the next 2 pages are the fee schedule. So let's talk about that. Arbitration actually costs a little bit more to file, actually quite a bit more to file than conciliation court would, which I think that's part of the reason they changed the rules and said, if it's under 15,000, go to conciliation court. So anything from 15,000 to 25,000 costs $1,250 to file arbitration. If your claim is over 25,000 up to 50, it's 1,500, and then anything over 50,000, it's $2,000. So that's quite a bit more than a court of law initial filing fees. But again, you don't have to have attorneys if you don't want to. And that's the bulk of what your fees are going to be, where if you went to court, you have a whole lot of other fees, whether it's expert testimony or attorneys, etc. So that's the next thing that is in there is the fee schedule. And then after the fee schedule, and it goes into more detail if you read through it, if you decide to adjourn, there's $100 fee. If you decide to cancel, there's a fee, but you don't have to pay the entire $1,250. So it kind of goes through every scenario. Then after that, after the fee schedule, there is another 10 pages on just kind of like frequently asked questions that you would have, and it answers them. What is arbitration? What's the difference between arbitration and the courts for dispute resolution? And it goes through everything. Can it be appealed? I already kind of told you that it can't, but it answers that for your clients. So you don't have to do that, which we don't want you doing. And it actually talks about, I love this part, if you can see, what would I have to prove to win an arbitration? Because this is the phone call I get all the time, is what would we, does it make sense to go to arbitration, Michelle, in this situation? And of course, most of the time my answer is, we can't give them legal advice. They probably need to talk to an attorney. However, these are the types of things that an arbitrator is going to be looking at. Is there a fact about the property that is material? So is it a material fact that is in dispute that was not disclosed? If it's not something considered a material fact, most likely you're not going to arbitrate over it. Did they know about that? So not only does there have to be a non-disclosure of a material fact, but you're going to have to prove that the seller knew about something being wrong. And then, did they not disclose this fact despite their knowledge? So those are the things that they're going to look for generally in the arbitration. And so I love that it's laid out like that, because then clients can look at that and kind of make a decision. Does it make sense for me to even bring this? Because maybe they look at it and say, well, there's no way the seller knew about it, so I guess it's not worth going to arbitration. It talks about the 24 months when you have to, that you have to file. It also talks about when you need to decide whether you'll use arbitration. And it talks about at the signing of the purchase agreement. I get this question from agents a lot. Well, can't we all just sign it later? Well, maybe not. If you want it to be a binding arbitration agreement, it has to be signed at the time of the purchase agreement. Could, during the process of going to court, all parties agree at some point to use mediation or arbitration or something else? They could, but they would not be required to. And oftentimes one of the parties is going to say no at that point, because they know, hey, it's going to cost the other side more to take me to court with, if I agree now, then they would have known at the time. So it's much, if it's something that they are considering and they really want arbitration, they need to do it at the time of the purchase agreement, because nothing is binding after that. We just don't know what people will agree to and won't agree to. And then it goes through, can you use an attorney? Absolutely. As I talked about already, who must sign the arbitration to make it valid and binding? Again, it has to be everybody, including the licensees. That is why we've always, at most of the Keller Williams that I work with, most of the brokers have said that they want their agents to sign it, because we don't want to be the party to stand in the way if our clients want to avail themselves of arbitration. So that's why agents have been asked to sign it. It's because if we don't sign it and everybody else does, and our client wanted arbitration, then we just stood in the way of them being able to do that. So we don't want that. So that's why we have generally signed the arbitration. There are brokerages that don't do that, but that is the theory behind why a lot of brokerages do sign it. When would I file an arbitration claim? Again, it's the 24 months after the closing, unless there's some sort of fraud or something. So yeah, and then it talks about the pros of arbitration and the cons of arbitration, which I just love that they're doing this, because then we don't have to try and talk to them about all the reasons why maybe you would want to and why you wouldn't. And there's some really good ones in there that, we may not have thought of. Discovery of documents is restricted, so it's going to be a lot less time gathering everything. The rules of evidence are not there in an arbitration. The arbitrator can make a decision on evidence any way they want, so they don't have to adhere to some of those. Now, there are a lot of people who like the rules of evidence, and as an attorney, I'm going to want the rules of evidence in a lot of the cases that I'm working on. So that's a reason why maybe I wouldn't want to sign arbitration, but it just depends on the way you're looking at it. And the idea is that you just lay out the information, and they can make their own decision on what they want to do, but they need to know all of these things. It's a lot quicker. It can be done within 30 days after the arbitration. You have a decision and it's over. So that can be really appealing to people, but you have no right to appeal. And that can be very disheartening to people who think, I'd like to have that ability if I don't like the decision. So this is a great question. Commission disputes are not covered in this arbitration. This is about the property. This arbitration agreement that everybody's signing is related to the property. When we talk about our disputes on commission between realtors, we handle that differently. That is done at the Board of Realtors and has nothing to do with this arbitration agreement. And then it goes through and talks about what some of the things you should look at when you're deciding if it's right for you. And it's just great. I mean, they really make some really great points. They explain who the arbitrators are, that they're usually, retired or people who are no longer active in the business, whether it's real estate lawyers, architects, building inspectors. Most of the time, it's a lot of builders I've had as our arbitrator. I've had quite a few building inspectors and appraisers I've had a few of. So they're people who are kind of in the business and have been for a long time. And then some retired judges and attorneys as well. And it talks about, how many arbitrators will there be? You can choose to have more than one arbitrator. It costs more. There's additional fees. I've never been to an arbitration with more than one arbitrator, but I can imagine if it's, hundreds of thousands of dollars in your claim, because remember, there's no limit on how much the claim can be. There's a minimum. It has to be over $15,000, but the claim can be in the millions. I mean, there's no limit on that. So I'm sure there have been arbitrations that are for a lot of money and they want a panel. They don't just want one arbitrator. So that is an option. And it explains exactly where you mail the documents, what documents you need, and it already showed you the fee schedule. And it explains how the respondent's notified. And then it talks about when, where the hearing will occur, how it will deal with evidence. I mean, this is just stuff that you're going to want to peruse. It's pretty general, because what they're telling you is the arbitrator is not obligated to the rules of evidence. So it can be a little loosey-goosey, but a lot of people like that, because the arbitrator can make the decision based on the set of facts in front of them. The one thing that they're pretty strict on is witnesses. Witnesses are allowed as well as exhibits, but they do have to be given to the NCDS 14 days prior to the hearing, so that they can be distributed and can be told to the opposing party, so they can be prepared. they need to know who's showing up on your side so that they can be prepared for that. So they're pretty strict on that time frame. They also talk about confidentiality, that the hearing, is closed and they consider this to be confidential. And you can object and how the rules are interpreted. I mean, it's all, you can read through this. I don't think it's something you want me to read through line by line. So, but
Yeah, that document is really good. That seems like it'll solve like all of the problems of helping them figure out if they want arbitration or not.
100%. I mean, when this came out, I was jumping up and down. It was like a party in my office because it was the best thing that I had seen. I could not believe that they had finally done it, because this is the only way our agents have gotten in trouble, is when they have tried to explain things that they just weren't equipped to. This isn't your job to explain this kind of stuff. And whether they try to give their opinion on things, this way you don't have to. It is all there. And when somebody calls you and they're upset and in a panic, it's clear as day on their next step. Who do I call? What is the phone number? Where do I go? How much is it going to cost? Those are the things they want to know. And before, we didn't know. We really didn't, because it was a sliding scale of fees and we never knew exactly how much it was going to be. And there was a website, but nobody ever answered the phone. And this is so much better. It has really made my life a lot easier. And I think as more agents become aware of it and use this pamphlet more, it's going to make your lives more easy, much more easy. So,
are you going to send this to us?
I can send it out. I'll tell Ann to send it out. I know that it's on Instanet. I know that it's available to everybody. The one thing I want to let everybody know is you don't have to turn this in. When this first got included in, when Mar put it out and people would submit everything to command, they thought they had to submit this entire pamphlet, maybe with initials on it or something. And you don't have to do this. This is strictly for you guys to give to your clients. But yes, I will, I'll let Ann know that you guys want to take a look at this. But again, it's an Instanet form and you should be able to find it anytime you need to.
Yeah, I can confirm. I did look it up while you were going through it, and it is on Instanet.
Oh, good. Yeah. So it should be every single one of your listings and every single one of your buyers. This is part of your initial kind of discussion with your clients. Should be part of it and given to them ahead of time. So then there's no question about, should we do arbitration or shouldn't we? Couple other, I think that was the whole packet.
Hey, Michelle, a quick question. I was on a call and I jumped on a few minutes late. So what happens in Wisconsin? I mean, I know this is Minnesota, but we're not required to do an arbitration form in Wisconsin. What's their recourse then? Is there something like this for Wisconsin?
There is not something like this as far as I'm aware in Wisconsin, unfortunately, although arbitration is afforded to people in every state. So this is but I don't know of the binding arbitration at the time of signing the offer in Wisconsin. So I'm just not
required, and it's not anymore, but I just wondered about this. Yeah, it's weird.
It is weird. I agree. I don't know. I haven't seen it in years with them, but that's a good question. Maybe we can get Brad to talk to the WRA and find out where they are on that and why. They just may feel that, people need to talk to an attorney if they want to get advice on this sort of thing and they don't want to be a part of it. And that sometimes is the way that, realtor associations work. So,
and that's what we've done. We just refer to an attorney because we don't know. But it's nice because this has always been such a gray area. People ask questions, and when it had changed, and when you say you can't give advice. I mean, I've never gone to arbitration, so I had no experience at all. But it comes up, and they want you to answer questions, and it's like you don't know.
Exactly. I agree, and so this has helped so much because our clients hated the answer. of, well, I can't tell you, or I'm not sure. Now you have this pamphlet that you give them and say, this should be able to answer any question you have. If it doesn't, then it's something that's so outside of the realm of our expertise that they're going to have to talk to a lawyer. But this is covering 99% of any question that anybody would have on it, and it's not coming out of our mouth. So that's the perfect thing. Okay, I'm trying to, can you see me?
Yeah, I still see your screen share. It looks like it's frozen, but I see your video too.
I'm trying to not be frozen. I'm impressed that I was able to find it to at least screen share with you guys, but now I don't know how to get out of that.
There
Sharing.
should be a,
There. Oh, did I do it?
got it.
Okay, sorry, everybody. Anybody who knows me knows the whole technology thing, not quite my thing. Okay, so now I want to open it up to questions, because that's the general everything about arbitration. And I'm hoping that, you guys can have any questions that I can answer about it. I'm here for a little bit more time. Anybody? Come on, Rob. I see you out there.
You did such a great job, and all the questions are answered in that pamphlet. I don't know.
Well, seriously, I've had so many less questions on arbitration since that pamphlet's come out. It's like, that was half my job, is trying to explain to people about arbitration. It's been a godsend, I have to say. It's the best thing that's happened to all of us in a long time. So, well, if you have questions on anything else, sure.
I do have one question. So I came in a little bit late to the meeting because I was on the phone with somebody. And so maybe I missed this, but if, let's say, the seller wants to arbitrate and the buyer doesn't want to, how does that work? Or did you already explain this?
No, that's okay. So at the time the purchase agreement is signed, the parties that want arbitration have to sign the arbitration agreement. If even one party does not sign it, it is no longer available for the transaction.
Got it.
So everybody, including agents. So if the seller wants it and the buyer doesn't, then it's done. You can't do it. All parties have to agree.
All right.
Yep, good question.
Got it. Thank you.
Mhm. Any other questions? This is the quickest I've ever done a class, as all of you can attest to who've heard me talk on and on, but okay.
Thank you very much.
Yeah, and I can still have Ann send it out. I know it's on Instanet, but if you guys want an email with it included, I'm sure she'll do that. Because it's great for you guys to read through so you understand it, and be able to point your clients in the right direction. So I'll have her do that. Well, it was good to see some of you. Hopefully I'll see you in the office soon.
Thanks.
Thank you.
Okay, thank you, everybody. Bye-bye.
Thank you.
Yep.